Hello everyone, welcome to Legal Darshan. In today's video, we are going to proceed in continuation of our previous video on a brief introduction on Hindu law. If you haven't watched the video yet, the link is provided in the description box below. Today's video deals with the jurisprudence and the intent of the legislature to bring forward a law named Hindu Marriage Act 1955 to govern the marriages in Hindu religion. Since the legislation was enacted in 1955, it becomes important to see how the marriages were governed earlier. In older times, the marriages were predominantly governed by Manusmriti in Hinduism. It was considered to be a sacrament which is holy, permanent, and eternal. The marriages prior to Hindu Marriage Act did not come with age barriers. That is, even a girl of 6 years was subjected to the marriage, and there was no space of consent between the bride and the groom. Since the older era considered the marriage to be a permanent eternal union, it also brought in some problems like no divorce. The marriage was a holy union for 7 incarnations, and hence no widow remarriage was allowed. So, even if a woman was widowed at an early age, her whole life she would be a widow. And even if a woman was subjected to utmost cruelty in her marriage, she could not demand separation. The Gandharva Vivaha, which is now a prevalent form of Hindu marriage, requires the consent of both the parties to marriage, that is, the consent of bride and the groom, was an unapproved form of marriage before the enactment of Hindu Marriage Act. Therefore, B.N. Rao Committee 1941 was established by Britishers to make reforms in Hinduism. Dr. Bhimrao Ambedkar was one of the pioneers in front to reform the caste and religion system based in our country. This committee aimed to eradicate the customary practices in Hindu law which deprived women of their basic rights. Prior to the enactment of Hindu law, the Hindu marriage was totally sacramental in nature. The intent of legislature was not to destroy the sacrament or holy value of a Hindu marriage, but to protect the rights of a woman. Therefore, the Hindu Marriage Act was partly sacramental and partly contractual in nature. The Hindu Marriage Act sets the age limit for both the bride and the groom for marriage. This age earlier was 15 for the bride and 18 for the groom, but later changed to 18 for the bride and 21 for the groom. Now the legislature has been deciding to move a resolution to make the age 21 for girls to marry. Another important feature of the Hindu Marriage Act is it allows consent to be an essential feature of marriage. Though the institution of justice aims to preserve marriage at every step, the legislature has provided the last resort of a disturbed and a cruel marriage to be the divorce. The legislature has also brought in the solutions like restitution of conjugal rights and the grant of judicial separation in order to prevent divorces between the married couple. With the introduction of concepts like void, voidable, and valid marriages, the legislature has tried to bring the sacramental value of a Hindu marriage and the human rights of a woman at equal footing. It also provides for the bigamy to be punishable under Hindu Marriage Act so as to protect the rights of a married woman. The Hindu Marriage Act, which is the 25th legislation of 1955, received its presidential assent on 18th May of 1955 and became effective from the same date. The implementation of Hindu Marriage Act comes with an overriding effect in its section 4. The section 4 of the Hindu Marriage Act reads, save as otherwise expressly provided in this act, any text, rule or interpretation of Hindu law or any custom or usage as a part of that law in force immediately before the commencement of this act shall cease to have effect with respect to any matter for which provision is made in this act. That is, if there is any provision relating to the matter in dispute made in the act, no previous text, rule, or interpretation of Hindu law would govern the issue. Further, the clause B reads that any other law in force immediately before the commencement of this act shall cease to have effect insofar as it is inconsistent with any of the provisions contained in this act. In the layman words, the section 4 of the Hindu Marriage Act upholds the prevailing of Hindu Marriage Act for marriages over any other law or practices or customs, and hence now becomes the primary source for governing the Hindu marriages in India. This was all for today's video. We hope for this video to be useful for you. For any queries, suggestions, information or questions related to Hindu Marriage Act or Hindu marriages or any other feedbacks, please feel free to contact us at legaldarshana@gmail.com. You can also drop the feedbacks in the comment box below. Thank you for watching this video. Please don't forget to like, subscribe and share.